Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
2 U.S. Code Chapter 9D, Office of Senate Legal Counsel. 2 U.S. Code Paragraph 288, Office of Senate Legal Counsel. A. Establishment, appointment of counsel and deputy counsel, Senate approval, reappointment, compensation. 1. There is established, as an office of the Senate, the Office of Senate Legal Counsel, hereinafter referred to as the office, which shall be headed by a Senate Legal Counsel, hereinafter referred to as the counsel, and there shall be a Deputy Senate Legal Counsel, hereinafter referred to as the Deputy Counsel, who shall perform such duties as may be assigned to him by the counsel and who, during any absence, disability, or vacancy in the position of the counsel, shall serve as acting Senate Legal Counsel. 2. The counsel and the deputy counsel each shall be appointed by the President pro tempore of the Senate from among recommendations submitted by the majority and minority leaders of the Senate. Any appointment made under this paragraph shall be made without regard to political affiliation and solely on the basis of fitness to perform the duties of the position. Any person appointed as counsel or deputy counsel shall be learned in the law, a member of the Bar of a State or the District of Columbia, and shall not engage in any other business, vocation, or employment during the term of such appointment. 3a. Any appointment made under paragraph 2 shall become effective upon approval by resolution of the Senate. The counsel and the deputy counsel shall each be appointed for a term of service which shall expire at the end of the Congress following the Congress during which the counsel or deputy counsel, respectively, is appointed, except that the Senate may, by resolution, remove either the counsel or the deputy counsel prior to the termination of any term of service. The counsel and the deputy counsel may be reappointed at the termination of any term of service. b. The first counsel and the first deputy counsel shall be appointed, approved, and begin service within 90 days after January 3, 1979, and thereafter the counsel and deputy counsel shall be appointed, approved, and begin service within 30 days after the beginning of the session of the Congress immediately following the termination of a counsel's or deputy counsel's term of service, or within 60 days after a vacancy occurs in either position. b. Assistant counsels and other personnel, compensation, appointment, removal. 1. The counsel shall select and fix the compensation of such assistant Senate legal counsels, hereinafter referred to as assistant counsels, and of such other personnel, within the limits of available funds, as may be necessary to carry out the provisions of this chapter, and may prescribe the duties and responsibilities of such personnel. Any selection made under this paragraph shall be made without regard to political affiliation and solely on the basis of fitness to perform the duties of the position. Any individual selected as an assistant counsel shall be learned in the law, a member of the Bar of a State or the District of Columbia, and shall not engage in any other business, vocation, or employment during his term of service. The counsel may remove any individual appointed under this paragraph. 2. For purposes of pay, other than the rate of pay of the counsel and deputy counsel and employment benefits, right, and privileges, all personnel of the office shall be treated as employees of the Senate. c. Consultants in carrying out the functions of the office. The counsel may procure the temporary, not to exceed 1 year, or intermittent services of individual consultants, including outside counsel, or organizations thereof, in the same manner and under the same conditions as a standing committee of the Senate may procure such services under Section 4301I of this title. d. Policies and procedures. The counsel may establish such policies and procedures as may be necessary to carry out the provisions of this chapter. e. Delegation of duties. The counsel 1. May delegate authority for the performance of any function imposed by this chapter, except any function imposed upon the counsel under Section 288b of this title. f. Attorney-client relationship. The counsel and other employees of the office shall maintain the attorney-client relationship with respect to all communications between them and any member, officer, or employee of the Senate. 2 U.S. Code Paragraph 288a, Senate Joint Leadership Group. A. Accountability of office. The office shall be directly accountable to the Joint Leadership Group in the performance of the duties of the office. b. Membership. For purposes of this chapter, the Joint Leadership Group shall consist of the following members: 1. The President pro tempore, or if he so designates, the Deputy President pro tempore of the Senate. 2. The majority and minority leaders of the Senate. 3. The chairman and ranking minority member of the Committee on the Judiciary of the Senate. 4. The chairman and ranking minority member of the Committee of the Senate which has jurisdiction over the contingent fund of the Senate. c. Assistants of Secretary of Senate. The Joint Leadership Group shall be assisted in the performance of its duties by the Secretary of the Senate. 2 U.S. Code Paragraph 288b, Requirements for authorizing representation activity. a direction of joint leadership group or Senate resolution, the Counsel shall defend the Senate or a committee, subcommittee, member, officer, or employee of the Senate under Section 288C of this title only when directed to do so by 2/3 of the members of the joint leadership group or by the adoption of a resolution by the Senate. B. Civil action to enforce subpoena. The Counsel shall bring a civil action to enforce a subpoena of the Senate or a committee or subcommittee of the Senate under Section 288D of this title only when directed to do so by the adoption of a resolution by the Senate. C. Intervention or appearance. The Counsel shall intervene or appear as amicus curiae under Section 288E of this title only when directed to do so by a resolution adopted by the Senate when such intervention or appearance is to be made in the name of the Senate or in the name of an officer, committee, subcommittee, or chairman of a committee or subcommittee of the Senate. D. Immunity proceedings. The Counsel shall serve as the duly authorized representative in obtaining an order granting immunity under Section 288F of this title of 1. The Senate when directed to do so by an affirmative vote of a majority of the members present of the Senate, or 2. A committee or subcommittee of the Senate when directed to do so by an affirmative vote of 2/3 of the members of the full committee. E. Resolution recommendations. The office shall make no recommendation with respect to the consideration of a resolution under this section. 2 U.S. Code Paragraph 288C, defending the Senate, committee, subcommittee, member, officer, or employee of Senate. A. Except as otherwise provided in subsection B, when directed to do so pursuant to Section 288B(a) of this title, the Counsel shall 1. Defend the Senate, a committee, subcommittee, member, officer, or employee of the Senate in any civil action pending in any court of the United States or of a state or political subdivision thereof, in which the Senate, such committee, subcommittee, member, officer, or employee is made a party defendant and in which there is placed in issue the validity of any proceeding of, or action, including issuance of any subpoena or order, taken by the Senate, or such committee, subcommittee, member, officer, or employee in its or his official or representative capacity, or 2. Defend the Senate or a committee, subcommittee, member, officer, or employee of the Senate in any proceeding with respect to any subpoena or order directed to the Senate or such committee, subcommittee, member, officer, or employee in its or his official or representative capacity. B. Representation of a member, officer, or employee under subsection A shall be undertaken by the Counsel only upon the consent of such member, officer, or employee. 2 U.S. Code Paragraph 288D, Enforcement of Senate subpoena or order. A. Institution of civil actions when directed to do so pursuant to Section 288B(b) of this title, the Counsel shall bring a civil action under any statute conferring jurisdiction on any court of the United States, including Section 1365 of Title 28, to enforce, to secure a declaratory judgment concerning the validity of, or to prevent a threatened failure or refusal to comply with, any subpoena or order issued by the Senate or a committee or a subcommittee of the Senate authorized to issue a subpoena or order. B. Actions in name of committees and subcommittees. Any directive to the Counsel to bring a civil action pursuant to subsection A in the name of a committee or subcommittee of the Senate shall, for such committee or subcommittee, constitute authorization to bring such action within the meaning of any statute conferring jurisdiction on any court of the United States. C. Consideration of resolutions authorizing actions. It shall not be in order in the Senate to consider a resolution to direct the Counsel to bring a civil action pursuant to subsection A in the name of a committee or subcommittee unless 1. Such resolution is reported by a majority of the members voting, a majority being present, of such committee or committee of which such subcommittee is a subcommittee, and 2. The report filed by such committee or committee of which such subcommittee is a subcommittee contains a statement of A. The procedure followed in issuing such subpoena, B. The extent to which the party subpoenaed has complied with such subpoena, C. Any objections or privileges raised by the subpoenaed party, and D. The comparative effectiveness of bringing a civil action under this section, certification of a criminal action for contempt of Congress, and initiating a contempt proceeding before the Senate. D. Rules of Senate. The provisions of subsection C are enacted, 1. As an exercise of the rule-making power of the Senate, and, as such, they shall be considered as part of the rules of the Senate, and such rules shall supersede any other rule of the Senate only to the extent that rule is inconsistent therewith, and 2. With full recognition of the constitutional right of the Senate to change such rules, so far as relating to the procedure in the Senate at any time, in the same manner, and to the same extent as in the case of any other rule of the Senate. E. Committee reports. A report filed pursuant to subsection C 2 shall not be receivable in any court of law to the extent such report is in compliance with such subsection. F. Omitted. G. Certification of failure to testify. Contempt. Nothing in this section shall limit the discretion of 1. The President pro tempore of the Senate in certifying to the United States Attorney for the District of Columbia any matter pursuant to Section 194 of this title, or 2. The Senate to hold any individual or entity in contempt of the Senate. 2 U.S. Code Paragraph 288E. Intervention or appearance. A. Actions or proceedings when directed to do so pursuant to Section 288b(c) of this title, the counsel shall intervene or appear as amicus curiae in the name of the Senate, or in the name of an officer, committee, subcommittee, or chairman of a committee or subcommittee of the Senate in any legal action or proceeding pending in any court of the United States or of a state or political subdivision thereof in which the powers and responsibilities of Congress under the Constitution of the United States are placed in issue. The counsel shall be authorized to intervene only if standing to intervene exists under Section 2 of Article 3 of the Constitution of the United States. B. Notification. Publication. The counsel shall notify the joint leadership group of any legal action or proceeding in which the counsel is of the opinion that intervention or appearance as amicus curiae under subsection A is in the interest of the Senate. Such notification shall contain a description of the legal action or proceeding together with the reasons that the counsel is of the opinion that intervention or appearance as amicus curiae is in the interest of the Senate. The joint leadership group shall cause said notification to be published in the Congressional Record for the Senate. C. Powers and responsibilities of Congress. The counsel shall limit any intervention or appearance as amicus curiae in an action or proceeding to issues relating to the powers and responsibilities of Congress. 2 U.S. Code Paragraph 288F. Immunity proceedings. When directed to do so pursuant to Section 288b(d) of this title, the counsel shall serve as the duly authorized representative of the Senate or a committee or subcommittee of the Senate in requesting a United States District Court to issue an order granting immunity pursuant to Section 6005 of Title 18.